episode of Lunch Hour Law. My name is Alet Uys and I'm a practicing attorney in Pretoria, South Africa. I made a part 1 of children's rights 2 weeks ago, so this is a very short part 2 just to follow up on that. There's a myth that I come across very often in legal practice, especially as someone that practices in the area of family law. During the divorce proceedings or children's court proceedings, people very often tell me that they've been informed or someone has told them that a child of a certain age is allowed to tell their parents where they wanted to live. So this is usually what a client tells me is, I've been told by a friend or someone that's been through a divorce or someone else that once my child is at the age of 12 or 13 or 14, whatever it may be, that they may actually choose where they want to live. I call it a myth because it is a myth. There is no provision in the Children's Act or anywhere else in South African law that actually allocates a very particular age of a child to that child having the right to say where they want to live or how often they want to see the parent they have contact with, etc., etc. There is, however, in the Children's Act 3 sections that I think need to be referred to in this context. So the Children's Act in South Africa is a certain piece of legislation. You can actually find it online. It's very easily accessible. And the 3 sections that I would like to read from it are as follows. The first section I want to read from is section 6, subsection 5, which reads as follows. A child, having regard to his or her age, maturity and stage of development, and a person who has parental responsibilities and rights in respect of that child, where appropriate, must be informed of any action or decision taken in a matter concerning a child which significantly affects the child. So if we focus on this, and I had to take out a particular part of this, section 6.5, I would say, I will take out the following. A child having regard to his or her age, maturity and stage of development. There is no particular age that's every child that is of such an age, maturity and stage of development as to be able to participate in any matter concerning that child has the right to participate in an appropriate way, and views expressed by the child must be given due consideration. Again, there are various ways of determining if a child is at an age, maturity and stage of development, if one looks at case law and how courts have dealt with this issue before. It's quite technical and it's quite specialized, so I will not try and go into that in this episode. But as you can see again, there's no particular age that is referenced in section 10. The third section that may be worth mentioning in this context of a child expressing his or her views and wishes is section, let me just quickly have a look here, 31 sub 1 sub A. Before a person holding parental responsibilities and rights in respect of a child takes any decision involving the child, that person must give due consideration to any views and wishes expressed by the child, bearing in mind the child's age, maturity and stage of development. So we again hear that golden phrase, age, maturity and stage of development. Again, no particular age is referenced. So it is a myth that a child that has reached the age, and the age I hear most often in this context from clients is 12. For some reason, someone somewhere told people that when a child reaches the age of 12 years, he or she is capable of telling their parents what they want to do, where they want to live, who they want to have contact with, etc. A child's best interests are of paramount importance. So that is something that we bear in mind when we ever talk about a child, where they live, their views and wishes. And then also important in this context, one of the aspects that will be weighed is a child's views and wishes, depending on their age, depending on how mature that child is and where they are in their life. Also important though is to note that a child's views and wishes do matter. So it's also not a case of a child must just be subjected to whatever their parents settle on in the divorce. If the child is older, they may be able to express themselves. It will depend on the particular context, and very often experts and family advocates are involved to help assess what the child wants. Thank you so much for tuning in to Lunch Hour Law. Very short, concise, nutshell version of something legal that you may be able to listen to in your lunch hour. Hope you have a fantastic weekend. Thank you so much. Bye.